move it back.
Good afternoon, everyone. My name is Zudaini Ahmed, and I'm the Director of Technologies, Operations, and Communications Programs, and this one as well. And I'm here to welcome the virtual audience and to let you know that if you have any questions, please type them into the chat. Somebody will be monitoring them, and we'll address those questions at the end of the talk. And right now, I'm going to introduce Bob Doherty, who is the instructor for the Ethics in Action course, and he will introduce our guest speaker, Commissioner Kennedy. Okay.
Thanks, Jenny. So good afternoon, everyone. First of all, it's customary at Dalhousie, respecting the Mi'kmaq people, to acknowledge that Dalhousie University is located at Mi'kmaqui. I'm getting to pronounce that, the more I pronounce it correctly, the more I pronounce it. I've even learned a few Mi'kmaq words, the work I do with Indigenous people, so it's not very far along in the language study, but it's beginning. Mi'kmaqui is the ancestral unceded territory of the Mi'kmaq, and we're reminded we're all treaty people. So a word about the Honorable Joseph P. Kennedy, who is Nova Scotia's Conflict of Interest Commissioner, and I was saying over lunch that many times at the Department of Justice, where I worked in my last 11 years in public service, my office was very close to the minister and the deputy minister. And oftentimes I would see Justice Kennedy coming in when he was head of the Nova Scotia Supreme Court, might have even been earlier than that period, and to speak on judicial administration matters and what was needed from the Department of Justice. But today was the first time that I met him. Actually, I've seen this individual coming in who was highly respected by the department and by I think the populace of Nova Scotia in terms of his judicial duties, but it's the first time that I met him.
Must have been a great honor for you.
So Nova Scotia's Conflict of Interest Commissioner, the Honorable Joseph P., or P as in Philip Kennedy, was born in Waverley, Nova Scotia. He received a Bachelor of Arts degree from 1965 from St. Mary's University. The arch rivals of St. X, where I graduated from, so we might have run across each other at the football games in the earlier years. And a Bachelor of Laws degree in 1968 from Dalhousie University. He was called to the Nova Scotia Bar in January 1969 and practiced law in Bridgewater with the firm of Kenny, Theakston, Kennedy, and Allen from 1969 to 1978. During his years of practice, he also served as federal crown prosecutor for the South Shore of Nova Scotia. And Chief Justice Kennedy was appointed to the bench as a judge of the provincial court in September 1978 and presided in the town of Bridgewater and Lunenburg. In July 1993, he was appointed as associate judge of the provincial court and then as chief judge of the same court in July 1996. During his years on the provincial court, Chief Justice Kennedy also held the position of president of the Nova Scotia Provincial Court Judges Association. In April 1997, Chief Kennedy was elevated to the Supreme Court of Nova Scotia, where he sat as a justice for 3 months before being appointed as the court's associate chief justice in July 1997. And a year later, in July 1998, he was appointed Chief Justice of the Supreme Court of Nova Scotia. And following his retirement, he was appointed full-time Conflict of Interest Commissioner. He has over 50 years of legal experience as a private practitioner, prosecutor, judge, and now the province's Conflict of Interest Commissioner. He is active in community affairs and is a public speaker of considerable note throughout Nova Scotia, as well as in many parts of Canada and the United States. So I asked Judge Kennedy, Conflict of Interest Commissioner Kennedy, to speak about the issues that he encounters as Nova Scotia's Conflict of Interest Commissioner. And recommendations of potential conflict of interest referred to him with respect to Nova Scotia government ministers, members of the Nova Scotia House of Assembly, and provincial employees. I also asked him to go beyond and deal with the role and powers as defined by the legislation, his experience as a commissioner, the issues with which he is traditionally engaged, and guiding ethical principles that he uses in developing his opinions and recommendations on potential conflicts of interest. And that would be of particular note to our class, as I indicated earlier, is from 6 different countries. They're in a professional leadership diploma program and come from different cultures and different legal systems. And so we're trying to look for them an adjustment process in terms of the rules and laws of Nova Scotia in terms of ethical decision making. So without further ado, Justice Kennedy.
Thank you very much, Bob. I'm told that you people want to be Canadians, want to stay in this country, I think, and do well and develop your leadership potential. That is, I think, a very wise thing for you to do, especially in this international climate. I often used to say about Canada, as bad as it is, as bad as Canada is, it's as good as it gets. All right? That does not in any way diminish the bad or change our need to correct what we can correct, but we should be objective about our place on this planet. This is not a bad place to be. And Nova Scotia particularly is a good place to be in Canada. I tell other Canadians we're small, we're not as rich as some other provinces, but we're the best looking Canadians. Much better looking than people from some other provinces. I am the Commissioner of Conflict of Interest. Why is that? That is because after I finished 41 years on the bench, 41 years of following up people's lives, 41 years on the bench, I needed something to do. I had to have an office, and my wife didn't want me home all day. So I became the Conflict of Interest Commissioner. I love this job. It's not that exciting, but it's fun. It's fun. It's fun to see people in government and how they think, what they're trying to accomplish, particularly because I'm dealing with young people, smart young people, smarter than you might think. A lot of these politicians surprise me, and they certainly have the best interests. Now, speaking of Nova Scotia, because this is in many ways a unique jurisdiction, but they do have, by and large, the best interests of the people of Nova Scotia at heart. They do not have the acrimony in politics that they do in many jurisdictions. They generally treat one another with respect. They do political things because they're politicians, but I admire them. I admire them. You know, people say you go into politics for the money. Baloney. Baloney. That's not in this country. Those young people with their abilities, if they put the time into the private sector that they put into government, they would be much better off financially, believe me, dramatically better off. So you say, well, why do they do it? Well, let's not forget about power. Power is it's an aphrodisiac. Power is something people like to exercise. But they also do it because I think they actually want to do good. They want to acquire some power to accomplish some good. Now, you may say, well, this guy that's Pollyannish, no, it's true. It's true of this province. It's what I've discovered. So I was a judge for 41 years, and that's the background that most commissioners have conflict of interest. There are 10 provincial commissioners in this country, one for each province, 3 in the territories, 1 in the Senate of Canada, and 1, the big dog who you had here yesterday, Conrad von Finkelstein. He's the big guy and a great guy. So I don't know whether you got a full sense of his personality yesterday, but I've gotten to know him and I like the guy a lot, and he does good work. I was a judge for 41 years. I was appointed a judge when I was 33 years old, which is dramatically too young to be a judge. I would never let that happen again. You'd say, why did it happen the first time? And I said, because the bus stopped, and when the bus stopped, you tend to get on, because that bus may not be coming around again. When you see the bus stop, get on. When you see circumstances that, using logic, indicate that these things are going to be beneficial for you down the road, then don't hesitate. People say some people are lucky and some people aren't. God knows luck is a huge factor, huge. And people who deny luck are, well, they're not right. Luck is a very, very important factor in relation to most aspects of life. But there are people who take advantage of their luck and people who don't. My advice to you is, if you think you're being lucky, go with it, run with it. On the Commissioner of Conflicts, conflict of interest, what is it? We tend to describe it by what it isn't. Basically, what the Act says, and everything in this province derives from the Conflict of Interest Act. I am a creature of statute. I was created by that Act. And everything that I do is specific to that Act. What the Act says, in its most basic, is this: if you are going to be in Nova Scotia government, if you are going to be a member of the Nova Scotia legislature, or if you are going to be a Nova Scotia civil servant, and there are in excess of 10,000 of those people. We have, I think, 11,000 civil servants. All of them subject to the Conflict of Interest Act, and all of them subject to my rulings. If you are going to be one of those people, either in government or a civil servant, you cannot use your government position to enhance a private interest. There it is. You cannot use your government position to enhance a private interest. And I can define conflict of interest, dramatic conflict, in 2 words. Donald Trump. Donald Trump is conflict of interest personified. When he was president of the United States, he majored in conflict of interest. First thing you have to do in government in Canada at that level is get rid of your businesses. Get out of business. If you have assets that you wish to retain, and I certainly hope that you do, if you're going to function at that level of government, that you've been successful and you've developed businesses and assets. If you have those things and you must retain them, then you put them in a blind trust. We create blind trusts. You turn everything over to a trusted individual or institution, and you stay out of it completely during the period of time that you stay in office. That's why it's called blind trust. You don't know what they're doing. You simply trust them to do their best. And you don't know what they're doing because if you have extensive holdings, for instance, sooner or later, they're probably doing business with the Nova Scotia government. And if you're the Premier of Nova Scotia and you have assets, you have interests in companies that are seeking contracts from the province of Nova Scotia, you don't want to know about that. You'll find that out 10 years later. How do you do that? You put it in blind trust. And I direct the blind trust and I approve them. I won't say what province, but I had a commissioner on the phone a while back, and he had a new premier. He said, I spent my morning, Joe, in an interesting activity. He said, I was trying to explain to our new premier that putting everything in your spouse's name is not a blind trust. Blind trust means just exactly that. You don't know what's going on. And it's you can't force an individual to rid themselves of what they've taken a lifetime to accomplish. Who would want to go into politics? Who would want to spend time trying to do the public welfare if you had to give up everything that you had? So we can't, that's not reasonable. We simply have to divorce them from those assets during the period of time that they hold office. So that's just one aspect of what we do. My job in this province is to write opinions, primarily. Since I've been in this job, I've written well in excess of 400 opinions. Well, how are those opinions? Why are those opinions written? They're written because people in government who have concerns, or other people in government who have concerns about their colleagues in relation to conflict of interest or perception of conflict of interest, they contact my office and they set out the scenario, they set out the facts as they know them, and they ask me, is this a conflict of interest? And if it is, what do we do about it? And I write opinions, and I expect those opinions to be followed. Surprisingly enough, I would say about 40% of the time, there really isn't any conflict there. They're mistaking what might appear to be a conflict of interest. I'll give you an example of that I've just been dealing with, where a person high up in well, I'm not identifying, I'm a person in power in the Department of Education, their spouse is a teacher, all right? You'd say, well, when we do something that affects the welfare of teachers, am I in conflict of interest in relation to my spouse? And they're worried about that, at least the perception. And the answer to that, and remember my point here is that so often what they think might be conflict isn't conflict. The Act says this, the Act is reasonable. If you are acting in a manner that deals with a broad class of people, i.e. teachers, and a family member happens to be within that class, but you're not dealing with the family member specifically, then what you do to the benefit of that group is not a conflict in relation to your spouse or your family member, because they do not receive the benefit because they are your family member. They receive the benefit because they are a member of a class, substantial numbers of people who have received government benefit. Now, if you were to become involved in trying to get your spouse transferred from one school to another, become specifically involved with your spouse, that would be a conflict of interest, because you would be using your office in order to enhance a public interest, a family interest. Your spouse is bringing public monies into your household. and you were in charge of public monies. You have substantial, so you can see that it's not, I was going to say subtle difference, it's not so subtle. Another example where, and this goes way back, and again, I'm not identifying, well, a minister had the requirement to change a tariff that a group of professionals could charge the province. The tariff was going up. The amount that these medical professionals could charge the province was about to be increased. His spouse was one of those people. One of like 600. Ministers concerned about conflict of interest. I am doing something that will mean that my spouse makes considerably more money, brings that money into my household. Is that a conflict of interest? Under the Act, no. Because you're not dealing with your spouse, you're dealing with that professional class. And the fact that your spouse happens to be a member of it is redundant to that situation. If, on the other hand, you were to do something that would specifically help your spouse that the spouse otherwise wouldn't have access to if it wasn't for your position, then that is a conflict of interest. It can't be done. And let me just say, go back generally to conflict about Canada and about what you're going to find, is that in this country we don't tolerate it. It's not that it doesn't happen, God knows it happens occasionally. But it doesn't happen with impunity. It doesn't happen with impunity. If you are consciously involved, advertently involved in creating a conflict of interest, and you are in government, then there will be consequences. Now you say, well, isn't that the case? And no. And again, I, get myself in trouble with that great republic south of here, conflict of interest in many ways is almost a way of life. Americans tolerate conflict of interest to an extent that we do not in this country, and haven't for years. And that's why we have conflict of interest commissioners in every jurisdiction. Who was the conflict of interest commissioner looking after Donald Trump? What office did he run Mar-a-Lago through when he was inviting foreign dignitaries to come and deal with him in his own private facility? When he had the G7 at his Virginia golf course, when he got his hapless Vice President Pence goes to Scotland for some important conference. And the conference, I think, was in Edinburgh. And Trump required that when he was in Scotland, he and his entire party, and you can imagine maybe 50 people, stay at the Trump golf course way up, and they were 200 kilometers away from the conference, staying in a Trump facility because Trump directed that they do that. Where was the conflict of interest commissioner who said, this is more than conflict of interest? I mean, that, and the incredible thing about it, they're so open about it. Nobody's trying to hide anything. One thing you got to say about Trump is that he doesn't hide anything. It's, so he must. Anyway, enough about Trump. But I find it fascinating, though, because in so many ways we're so like Americans. Americans certainly don't distinguish. Oh, they, aside from the fact that we're socialists, according to them, and that our healthcare system doesn't work. That's a regular. And then we're polite. We're very polite. The whole line in the States is that if you step on a Canadian's foot, he says, I'm sorry. But we're not. We are very, very much like Americans. We come originally from either British rebels or British loyalists, but we're very, very different also. And you take a look at the culture, just look at the gun culture, for instance. Completely different. Anyway, enough of that. Back to conflict of interest. We are different. My point being this, that we are different in how we run our governments in relation to conflict of interest as opposed to what the Americans would tolerate in some other countries. We're not alone. I mean, we got the Canada on the corruption index last year. There's a World International Corruption Index. I think we were number 10 after places like Norway and Iceland. The United States, I think, was around 26 or something. So that's a considerable difference. The other factor that is so important for me to communicate is that I am independent. I am independent of government. I don't work for the government. I'm appointed by the legislature. 51 people in the legislature have appointed me, and I work for the legislature. I don't work for the government. I don't work for the opposition. I don't work for the third parties or the independents. I'm appointed by the legislature. And that independence is crucial. We had, surprisingly enough, there was a representative here from an island, a group of island nation in the far South Pacific, beyond Australia. And for some reason, and he explained it to me, but I still can't figure it out. They want to reform their government, and of all the places in the face of the earth that they decided to look at, maybe not the only one, but certainly one of the ones, they're looking at the government of Nova Scotia as some sort of a role model. And I said, why are they looking at this little province in this big country? And he said, well, the population is just about the same, about 1 million people. I guess that was a factor. And he said, and we're both fishing countries. We're fishing places. And that seemed to have, that was good enough for me. So they came to study my office because they want to set up a conflict of interest regime, much the same as they have in Canada. But here was the kicker. They wanted all of the benefits of the Conflict of Interest Act, but they had nobody in an independent position to oversee it. And they had no intention, apparently, of putting anybody in that position. I said, well, listen, when you get the act, who's going to enforce it, oversee it? And they said, oh, the Attorney General. And I said, the Attorney General is an important factor in your government. How's your Attorney General going to oversee conflict of interest with his or her colleagues? How can that be seen? How can you develop a level of trust? That's just government looking after government. So you can, that's just window dressing. You can create conflict of interest act that has all the bells and whistles, but unless you got a guy like me who's independent of government overseeing the thing, then it won't work. Or it won't work in the sense that I basically said you're wasting your time creating a conflict of interest act that doesn't call for an independent commissioner. And they said, well, okay, we'll take that back and they may want to talk to you again. And I said, well, I've got one proviso if you want to talk to me again. It's going to be on your island. I'll come out there and talk to you. Well, they haven't called me since. I don't think I'm going. But but that makes my point about independence, and that goes back to the judiciary. Canadian judiciary are absolutely independent. Nobody tells a Canadian judge what to do. That's why we do so many stupid things. Nobody tells us what to do. Canadian judges make their own decisions based on what is presented to them. They're not told by government. We have government in our courts daily. The government is a party to 60% of the stuff we do. What kind of a court would you have if that government had control over the judge? And we were working with Ukrainian judges before the war. We had we had the Ukrainian judges over here, and we sent judges to the Ukraine to talk to them over there. And it became, in my mind, a wasted effort because the Ukrainian judges were not independent. And if you have a judiciary that's not independent, then there's nothing, we can't help. There's nothing we can do with a judiciary that doesn't have control over its decision-making power. And it was interesting. The Ukrainian judge told me, this is interesting. He said, I am independent as long as certain people aren't before me. So I'm allowed to be independent with the entire Ukrainian population, except for certain people in power. And when they're before me, I'm no longer independent. Well, you're not independent at all. Not independent at all. So the Chief Justice of Canada at the time was Beverly McLaughlin. And we had judges all over. Canadian judges have a pretty good reputation internationally. We're regularly asked to assist in relation to other judicial systems. And we had people going all over, going South America, going all, particularly the Ukraine, but not only in the Ukraine. And I spoke to the Chief Justice of Canada, McLaughlin, who's now a very successful novelist, who knew. This is a woman who was the Chief Justice of Canada, used to get up every morning, 5 o'clock in the morning, and spend 3 hours writing her novels. You'd say, well, wouldn't that be a conflict? No, she didn't publish until after she retired. Just what an amazing, amazing woman. Anyway, back to the point. I went to her and I said, Chief, I'm not sure of the benefit of sending our judges to places like the Ukraine. What can we do? How can we help judges who do not have independence? And she said, Joe, they're trying to be. That's why we're sending judges. They want to be independent. And we've got to go over and encourage that. And there it is. That's why. So yeah, back to independence. Conflict of interest, not as independent as I was as Superior Court judge, but believe me, I'm independent. If government tried to influence my decision, and they wouldn't do that. But if they did, I'd be publicly and demonstrably resign the next day. So it doesn't, independence happens and it works, and it allows me to be objective in relation. I don't, to be perfectly honest with you, I never think about what segment of government is coming before me I'm dealing with. Now, if I'm dealing with a government minister, obviously, and I do deal with a lot of ministers because they have decision-making power, great decision-making power, and therefore the idea of conflict is a regular factor. What I didn't say about conflict, should have said earlier, is two kinds, real and perceived. Now, real conflict, easy enough to, when we describe Donald Trump and Mar-a-Lago, that's real conflict. Perceived conflict is a situation where conflict does not actually exist, but it doesn't look good. The perception is bad. And that's virtually as bad as real conflict. Because what we're dealing with in relation to all of these factors, the bottom line is the public trust. And if the public perception of an action looks like conflict of interest, then it might as well be. So what do you do when you got a situation with perceived conflict? And that's, I deal with more perceived conflict than real conflict, dramatically more. When you think about it, I hope so. Perceived conflict, you don't necessarily have to say you can't do this. You give them direction about how to do it that best deals with the perception, i.e. disclose and recuse. Say, well, recuse, you're not doing it, but I mean how to stay in your position. Disclose your conflict and then recuse, stay out of it. Make it publicly known that because of the fact that the guy seeking the contract is my brother-in-law, I am having absolutely nothing to do with this. It will go through the usual required processes, and I'm out of it. I'm telling you, he's my brother-in-law. I don't want to and I don't want to get sandbagged with it 3 years down the road. Don't come to me 3 years from now and say, that guy was your brother-in-law. I told you that. And I told you I stayed out of it. And that's the kind of advice I give. I tell them, and then I give approval, and that's I can approve actions under the Act. And once I approve it, it really doesn't make any difference whether it was conflict or not. It's on me. They've done the right thing. They went to the commissioner. The commissioner assessed the situation. The commissioner either approved or told them how to do it. And I did it the way the commissioner said. So I did everything right. And that would be doing everything right. And then it turns out 3 years down the road that it wasn't right. That's on me. And I regularly say that. Once I give an opinion, I own it, not you. And don't think they don't. One of the reasons my office is so busy is they want those opinions on file. So that if something did blow up 5 years down the road, look what I got. Look what Kennedy said 5 years ago. I was only following the instructions of so it's, cover your derriere is a factor in relation to conflict of interest commissioner. That's one of the reasons I'm as busy as I am. But the kinds of things that we run into and why, again, there's advertent conflict and inadvertent conflict. Advertent conflict. If somebody these are all allegations, okay? We're dealing with allegations here. Allegations about the mayor of New York. If it's true, the allegations in relation to the mayor of New York, the day he went into office, he and his cronies started trying to make as much out of that office as they possibly could. This guy gets elected the mayor of one of the most important cities in the world. And what's he do with it? From day one. Now, it may all turn out, and I'll take it all back. It's God knows judges, no allegation. It's all allegation. But if it's true, it's sad. And it goes back to my point that in some cultures, they almost expect their people to be. Anyway, not here. Let's give you good examples of advertent conflict is when I had a situation where a Nova Scotia government employee advanced and then sat on a board that approved a multi-million-dollar contract And subsequently, we find out that it went to a former partner who he was still otherwise. Right? That's advertent conflict. As a matter of fact, close to corruption. That's the kind of thing that my office turns over to the prosecution service. There are examples of real conflict, very, very few, that it's my obligation to bring in the prosecutors. I turn it over to them. Another independent office, by the way. Government does not tell our prosecutors who to prosecute and who not to prosecute. Anyway, that's advertent conflict. Happens very, very rarely. Shocks us. The most common conflict is inadvertent, and that happens sooner or later. It's going to happen to virtually everybody. And I mean, let's go back to that brother-in-law. The guy's, say, a director with I'm making this up, director with the Motor Vehicle Act, under the Act, Department of Highways, discovers that his brother-in-law just got hired by the Department of Highways in Sydney. So this guy's a director overseeing his brother-in-law and convinces me he had no idea the guy had even applied for the job. He said, "We're not that close." I guess we're not that close, he said. But it doesn't look so good, you know. It's a perception. What do you do with that? You disclose, you recuse, you spell out that the individual applied along with other people seeking that job, that an independent group assessed the applicants. This individual was chosen as the best applicant. And as a matter of fact, the people who did the hiring in Cape Breton had no idea he was related to the director. That's inadvertent conflict that can be dealt with. Nobody's to blame. You'd say, well, what about the brother-in-law? Shouldn't he have disclosed? Well, probably, but as the guy said, we're not that close. But when you explain the situation and the criteria that you use for perception, important to think about the criteria. When I am assessing perception of conflict, criteria I use is what would a reasonable person, properly informed, conclude? Two factors. A reasonable person. I mean, some people find conspiracy everywhere. What would a reasonable person, properly informed, conclude? And if I find that a reasonable person, properly informed, notwithstanding the perception, would not find a conflict of interest, then I say so. If, on the other hand, if I find that a reasonable person, properly informed, even though there might not be a real conflict, would have every right or every likelihood of forming the perception, then I'd say that too. But that's the criteria. What kinds of things do we have? We got what's happening today in our society. Lots of people have two jobs. It's a common situation. You have to have two jobs very often to meet the expenses, meet those mortgages. So they're working for the government during the day, and in the evenings and the weekends, they're working in private business. Given expertise that these people have, very commonly what they're doing in private business is somehow connected to their government function. Is that a conflict of interest? Well, sometimes it is and sometimes it isn't. Let me tell you when it is, when regulators are working for the people they regulate, which we run into, where people in a position to regulate with considerable power. Regulators have power. They can shut restaurants down. They can take semi-trailers off the road. They have all kinds of at-root power. And when those people who have that quasi-judicial power, that kind of ability, when they are in their spare time working for people in the industry, because they're sought after, then that's a pretty good chance they got a conflict of interest. I had a whole department of government where we discovered that for years this kind of thing happened, and they felt innocently. And my ruling was that you tell your staff they're either government regulators or they're working for the people they regulate. They're not going to be both. They either give up the government job or they give up the private job. The perception is terrible. The public, what about the other, for instance, say it was a restaurant owner, and this guy is, what about the other people in the industry when they see this? What if the individual was what I call Weight Watchers, the people who regulate transportation, big semi-transportation, and what if they're working for a trucking company in their spare time? How do you have public? What about the other trucking companies who have to satisfy these regulations, who've had their trucks hauled from the road? When they see this stuff, they lose the public trust. And so that's what my job is, to try to keep people from compromising the public trust, and largely to help people avoid that when that's what they want to do. That's what they want to do. And occasionally I'm supposed to do public inquiries, and I wouldn't mind doing that because I'd like to do some inquiries, because I'd like to see my name in the paper. But I just can't find any. I'm looking for them. The reason I haven't been doing public inquiries, I've had requests for them, but there's a threshold test. You can't do a public inquiry on a whim. You accuse somebody of conflict of interest and you launch an inquiry, you are compromising that individual. So you don't do it on a whim. Whoever wants the inquiry has to satisfy me on the balance of probabilities that there's a problem there. He has to satisfy me first. And I've had requests for public inquiries that didn't meet the threshold test. Some of them, frankly, I thought might have been political. And others come from private. Not only do politicians bring things to my office, but the Nova Scotia public do also, although very few of them know they can, which is my, I'm going to have to advertise a little bit. Let me talk about Nova Scotia as compared to other provinces. My colleague in Ontario has a staff of 6 lawyers on staff, very, very investigatory. They're out there looking for conflict all the time. Believe me, they're finding it. You might be familiar with that green belt situation in Ontario. That was the conflict of interest commissioner who blew that wide open. It was a situation where the government was, people in government were making green belt protected properties available to certain developers. Those properties were supposed to be saved as green belt for those purposes. And suddenly prime, and believe me, they're prime properties. Suddenly these prime properties were ending up in the hands, some of them in the hands of developers. How was that happen? Well, the conflict of interest commissioner, well, I'm getting the axe. They kind of, that's my problem, is I love the sound of my own voice. The conflict of interest commissioner blew that wide open, became a huge political issue. About the member of civil service who was involved, in a lot of trouble. Directors had to give the developers had to give the land back. So it's again an example of not tolerating that. So that office, huge office, full-time, basically full-time job, former judge. It's great, he's got his full pension and a full-time job too. So anyway, thank you. That's it? Okay, what about that?
So can we have some questions, Commissioner? They're quite an unruly group once we get them going, so if you're prepared to kind of adjust them into the Canadian culture of a conflict of interest.
Questions are like, you're a fun group to talk to. Listen, the advice I always give, I used to talk to first year law students. Two things, just a simple thing, got nothing to do with this, but remember it. Always be where you're supposed to be when you're supposed to be there. Very simple advice. Always be where you're supposed to be when you're supposed to be there. You say, well, doesn't everybody do that? No. No, don't keep the judge waiting. Don't do that. Now, occasionally, beyond your control, some people, it's a way of life. Always be there. Be there ready to go. Ready to go. People are always watching. Don't think people aren't watching. You won't realize that until 10 years down the road, but you'll find out people were watching. And you conduct yourself that way. Joe DiMaggio, I'm going to quit it right here. Joe DiMaggio, great ball player, Yankees, New York Yankees. Last year of his career, shouldn't have played. Had a bad ankle. Shouldn't have played, but he did. Hits a grounder down the line, play it first, runs it out as hard as he can, comes back to the dugout. His ankle is obviously hurting him very badly, and a young rookie sitting beside him said, Mr. DiMaggio, he said, with that ankle, I don't think you had to run that out. You didn't have to run that hard. DiMaggio said, I did have to run that hard, kid. He said, there might have been someone here who never saw me before. I used to say that to my judges. Every day you go in that courtroom, there are going to be people there, their entire experience in a courtroom for their lifetime will be that day with you. You'll remember that. Okay, thank you.
Could we have a few questions, Commissioner?
Oh, is that a question?
Oh, Rufus.
Thank you so much, sir, for the deep insights on what you do, what your office do. In fact, you actually took it so deep, so closer to us. So thank you for that explanation, sir. Yeah, the point that actually got my attention was the fact that you mentioned that your office is independent, and I really appreciate that.
Are you hearing?
You also said,
Yeah, sorry, go ahead. My hearing's a little bad, but he's going to repeat what I missed. So
I'd like to
keep going. Yeah.
You said your office is independent.
Yeah.
And you are also appointed by the legislature.
Yeah. Okay. I know what's coming. Here we go.
Yeah.
Yeah. Okay.
Has there been any time that there is a kind of impunity from the legislature, the same legislature that actually appoints you?
Yeah.
And if there is, I would like you to share how you were able to solve it without any.
Yeah. Well, you ask firstly a question I've heard many times before, no wonder, and secondly, it's a good question, and you're going to have to trust me on this one. Once Canadian judges are appointed, they don't pay any attention to where they came from. And I can tell you, you can take a look. I was appointed by the Liberal government in Nova Scotia when I was 33. You look at my record on the bench over the years, I don't think you'd ever see any prejudice in favor of the Liberal government. Sometimes I found in their favor. Sometimes I found against. I know, and because I'm totally independent, I don't care. I'll give you, it doesn't involve the Liberal government, but I'll give you an example. I did Morgentaler, the abortion doctor in Nova Scotia years ago. And at the time, the government passed legislation that was not constitutional to try to keep that abortion doctor out of Nova Scotia. 73% of Nova Scotia population wanted him to stay out. I knew that. I knew what the statistic was. 73%. But the law that the Nova Scotia government passed, they didn't have the power to pass. It was unconstitutional. All right? So they gave it to me. First thing I did, first day, as I said, first declaration I want to make is that I'm Roman Catholic. I'm Roman Catholic. And if you have any difficulty with that, I want to hear it today. I want to hear it right now. And I said, if I thought that was going to have any influence on what is going to be a constitutional decision, really, it's easy to say, but it wasn't about abortion. It was about a proper interpretation of the Constitution. If I thought it was going to have any difficulty, if it would cause me the least difficulty, I would not take this case. But I don't want to hear 2 months down the road, oh, by the way, the judge in that case was a Roman Catholic. All right? Going to deal with it today. Those are the kinds of things that I can tell you that I found against the government. I found against the Nova Scotia government. Went to the Supreme Court of Canada, was upheld 9-zip by the Supreme Court of Canada. What I am saying to you, and you're going to have to trust me on it, there is an element of politics in relation to the appointment of judges, not nearly. They have to qualify now. There's a committee that assesses lawyers who want to be federal judges, and they determine they either find you qualified, highly qualified, or not qualified. I can tell you that 95% of the judges that come to the federal courts have been determined to be highly qualified by this committee, which involves lawyers and other judges. And so, does the political power have the power to influence? Yes, but they have to pick the people who have already determined to be. You can't just take a political crony and put them on the bench if they can't get through that committee. And I can tell you that regularly they can't. The committee, firstly, you'd have to think you were a pretty good lawyer or you wouldn't apply. So only people who think they're good lawyers apply to that committee. And of that group, something like 43% are either found qualified or highly qualified. So only less than half of the people who get into the pool. It's called getting into the pool. They used to come to me and they say, how do I become a judge? I'd say, get into the pool. And what happens after that? It's not always straight traditional politics. There's all kinds of reasons for appointing judges. Sometimes it's diversity. Sometimes they want a certain male-female balance on a court. They want diversity. They want all kinds of things that are not necessarily classic political issues, but they are factors that influence the appointment. So yes, there's influence, but they have to be in the pool. And secondly, if you'd be prepared to trust me, I can tell you that once a Canadian judge is on the bench, don't try to influence them. And if you do, well, no, not influence. Lawyers try to influence. Don't try to direct them. because they won't put up with it. But judges don't do it themselves. When we discuss cases with other judges, we never ever discuss the outcome. And we don't discuss the evidence. We discuss the law. Judges get together all the time and discuss the law and their interpretation of what do you think of this section? How do you interpret that word? Judges, in order to survive in that job, you have to work together. Because one of the reasons is that all of the lawyers these days are specialists, and the Supreme Court does everything. So you appear in a courtroom and all these young specialists in front of you. Now, prime example for me, my background was criminal law. Supreme Court of Nova Scotia, about 20% of what it does, criminal law. The other 80%, I had no background in. So all of these specialists would be before me, knowing more about the law than I did, because it was their very narrow specialty. And I used to say, you're a lucky guy, you got a blank slate up here today. I have no preconceived ideas about this law. So you do your best, whoever does their best. Anyway, yes, you raise, a question might be, well, who is going to select? You know, there's politics in every element. They said, well, give it to the Bar Association. Let the Bar Association pick the judges. Let me tell you, there's more politics at the Bar Association. More politics at the Bar Association than there is in Ottawa. I'll tell you that everything has, so we've kind of reached, what we've gotten to is a situation where we're getting good judges. And you may think that Nova Scotia, we've had some bad publicity lately. But the other problem that we have is that everybody just see a judge as a judge. They don't distinguish between the courts. Courts are very, very different. The Provincial Court of Nova Scotia is a completely different court than the Supreme Court of Nova Scotia. Provincial Court, they're appointed by the province. Supreme Court of Nova Scotia, despite its name, they're federal judges. They're appointed from Ottawa. Chief Justice is appointed by the Prime Minister. And you'd say, well, the Prime Minister appointed you. Don't you have any allegiance to the Prime Minister? I used to say, I don't even vote. Judges don't vote, as a matter of, we're allowed to vote, but judges, as a matter of course, don't even vote, because we don't. Anyway, there was another good question out there somehow.
I just want to add, you mentioned earlier when we were talking before we came over about the when lawyers become judges, that they have a training program, what the first day of the training program.
Oh, yeah. Oh, no, that's an important thing.
I think it's really important for this class.
Thank you. When you're appointed a federal judge, you go to federal judges school. Class takes you, what, 8 years to become a doctor, it takes you 3 weeks to become a judge. These people are all high-end lawyers who are going to become federal judges. They've already been practicing law for 25 years. They're at the top of the profession. So they go to new judges. First class, they come in, they say, take some time, take a sheet of paper, write down your prejudice. Write down all of your prejudices. And they'll be there, what? I'm not prejudiced. Yes, you are. Yes, you're prejudiced. Everybody is prejudiced. And I'm not necessarily talking about the classic racism and sexism and ageism, but everybody has prejudices. And that is, for instance, we are prejudiced against certain personalities. We're prejudiced against all, and it's very important sometimes to do a self-analysis on your prejudices so that you don't let them influence your decision-making. And I said my prejudice, the short period of time I did family law, which is a terrible place to be. In family law, you're choosing bad over worse very often. At any rate, the short period of time, I realized I was very much prejudiced against fathers who didn't support their kids. I had done years and years of criminal laws dealing with murderers and armed robbers and all that stuff, and I did that not emotionally. But I got into family court, and I get these guys standing there. She won't give me access, so I'm not going to pay child support. So that's the child's fault, isn't it? I used to say to those guys, you want the new boyfriend to pay for your kids, do you? Is that what you want? And that's the way I used to react. And I realized that that's not the way. And when judges get mad, the first thing you got to do, it's the Bible, get off the bench. As soon as you see that you're losing your temper, get off the bench. You just say, I'm on air. I'll be back. Give me 5 minutes. Because you're going to. You say judges aren't accountable, for instance. Excuse me, from the time you walk on that bench to the time you leave, that recorder is on every word. You have a bad 5 minutes, it's your career. Bad 5 minutes, it's your career. You have to have a governor in your head, and you have to not only think about what you're actually saying, but you go back to, and this applies to my present job, how will it be perceived? What you are saying, what you think you're saying, how is it going to be perceived? And that's the governor in your head. And as soon as you start to lose that a little, get off the bench. Anyway, enough. You raise a good question. It's not a perfect system, but it produces pretty good judges.
So I think there was another question at the back there.
Yeah.
Thank you, sir. My name is Emmanuel. I want to find out what kind of consequence might public official face for violating these kind of guidelines.
What is that?
You wanted to know what kind of penalty for any public official who violates the guidelines or your recommendations.
Yeah, that's good. I either deal with it myself or I turn it over in egregious situations, advertent conflict that looks like corruption. I turn it over to the Public Prosecution Service, and they prosecute it under the Criminal Code of Canada. And the penalty, the act itself of egregious conflict, there's a summary section that has fines up to $50,000. But if they charge you with corruption, you do up to 10 years in prison, maybe more. If I deal with it, and if, for instance, I gave direction and it wasn't followed, it was demonstrably ignored, that's an oxymoron. If it wasn't followed, then I have the immediate ability to fine up to $10,000, which is this day and age. But if it was, if it was anything of any significance, I'd turn it over to people. If I do a public inquiry, I have all the powers under the Public Inquiries Act, and you can look at that. I can subpoena witnesses, I can put people under oath, and I have all kinds, a whole new package of penalties. And the first thing I can do is take your job. I can take your job and I can fine you, or I can incorporate it as part of a criminal code process. So in answer to your question, the quick answer on the kinds of stuff even they did expect to see, I can fine up to $10,000. So the penalties, it's enough. You'd say, what is enough, It's another, we're not, putting people in jail doesn't solve do you know that 70% of the people in jail in this country haven't been tried yet? They're waiting for trials. 70%. They've never been found guilty of anything. And some of them won't never be. So you can spend 2 years on remand, waiting your trial, and then be found not guilty. Say, I'm sorry, That's why we think before we put people on remand. You get the public reaction, they say, how come they didn't lock that guy up? Why didn't they lock him up? Why, firstly, we often don't have the prison cells. We got so many people on remand. And two, if you lock somebody up prior to trial, you better be pretty sure that there are going to be convictions down the road. You'd say, well, how can a judge do that? Well, I'm not going to be the trial judge. It's the other thing to do. What judges who do preliminary matters where they make judicial decisions that affect the people don't do the trial. It's all brand new. You say, well, yeah, but the judge who does the trial, he knows. No, he doesn't, or she doesn't. They don't. They may know the matter was before the court. They pay no attention to anything happened up to until they walk into their courtroom and they take over that trial. They don't care. It's their trial, and then they take over and they run it. But anyway, there's that. Yeah.
In terms of public contracts, is it allowed for government officials, relatives, or family to bid or lobby for public contracts?
Okay, so is it illegal for a government official, relatives of a government official, to, I suppose, friends as well, to bid on government contracts?
To bid on? No. Nor is it legal for anybody.
Not that they would decide, but for them even to bid.
Yeah, okay. No, you can't do, people in government can't do business with the, well, okay, let me qualify this. As a general rule, you cannot do business with government. You certainly can't do business in relation to things that have happened since you became a part of the government. Here's the problem with it. Many people have business with government in place when they got elected. And I'll tell you where we often see it today is low-cost housing. Everybody's trying to get into the low-cost housing business. Thank goodness. Thank goodness we need low-cost housing. So a lot of these people coming into government are involved with associations and businesses building or trying to build low-cost housing around this province. And when you've got low-cost housing, you're looking for government subsidy. The government subsidizes people building low-cost housing because it's a desperate need. So, okay, a guy involved in a low-cost housing, say a nonprofit, gets elected. How do I deal with the fact that he's got A, low-cost housing, and B, his tenants are going to be government supported? Okay. Now remember, all this happened before he got elected. Nothing to do with his influence as a government member. It was already done. Now, he certainly has to divorce himself from the situation completely, because what will happen that involves is tenants applying for subsidies in the properties. Okay. They're looking, all this stuff is good. This is public good. Low-cost housing is public good. Rental subsidies are public. It's not like anybody's trying to pull, it's just you can't have people in government going to government for public money. You can't do it, and as a matter of course. And when they're in situations where it has to happen, remember I talked to you about blind trusts. You wouldn't need a blind trust in that situation, but what I would tell the guy is tell the authorities your background and get out of it. Turn it over, get out of the...
Declare and recuse.
You would, in that instance, you'd declare to the people in your department. You know, you might be the deputy minister, you might be the guy, but you would declare to somebody up the ladder. You'd make sure that it was well known that you had been involved. I mean, being involved in trying to support public housing is not a crime. Something that good people do, they're trying to do, but they just can't be taking public monies anymore.
Other questions?
Yeah.
No. So what would, just one last question here, if we don't have any from the audience. What would be the most frequent types of things that MLAs ministers would refer to you? Or what types of, would it be gifts, travel, or is it purely just financial business relationships?
No, we don't. I didn't even get into disclosure. Members of government have to disclose everything they own beyond $10,000. And it all comes to my office and it's all on, it's on public record. It's not only, but what they don't realize is their spouses also have to disclose. And they don't mention that to their spouses when they're running. Often they don't know. It comes as a big surprise to them that their spouses have to do. You have to disclose your family assets. Where does it take a company like Liant or what's the big Nova Scotia corporation? Utility.
East Coast Power?
Yeah.
Nova
Anyway,
Scotia Power?
yeah. Nova Scotians hold shares in that. Everybody owns shares in it. And sooner or later, they do business with the Nova Scotia government. So you got shares in a company that's doing business with. How do you handle that? Well, you disclose and you declare, and I look at everyone that's given to me on in the specific and determine how can you handle this that will maintain the public trust. Depends on how many shares you got. How many shares you got. Judges recuse all the time. We recuse, especially small towns. I had been a prosecutor in a small town. I became a judge. Half the people who came before me charged with offenses had been people who I had prosecuted. We were almost on a first-name basis. I knew these people. And yet I had to adjudicate their situations in a manner that appeared to be fair, give them fair trials, which I could do. I could shut that off, just move on. But what's the perception? So I used to go to Halifax back then. I'd say, send me a judge. We got to get another judge down here. I get such and such. My chief judge eventually said, Kennedy, we can't be sending judges out of Halifax to Bridgewater twice a week. So get on the bench, put it on the record that you prosecuted the guy, that it means absolutely nothing in relation to the matter before you, and go ahead. Because you can't, the trier of fact in Canada, whether it be a judge or jury, cannot know the prior record of the individual. So we have problems with juries. The jury gets sequestered, and the newspaper, the front page always used to be, this is what the jury wasn't told. And they start with the criminal record. The guy had 4 previous convictions for doing the same offense. Can't tell the jury that. If the jury finds that out, it's a mistrial. You say, why not? Well, every trial is a new ballgame. And there would be the honest enough perception that if a jury knew that the guy had been convicted 4 times before, it would be hard for them to be unbiased in relation to the matter that was before them. So the guy can't, maybe he didn't do it this time. Maybe it's not him. I used to be also defense counsel. I often used to say, most of my clients are guilty, but not necessarily guilty of what they're charged with. Very often guilty, but not guilty as charged. That used to be a big theme in my defense. I was charged with dangerous driving. You try to get it reduced to a motor vehicle offense. You try to get murder reduced to manslaughter. That's a huge, murder gets reduced to manslaughter. That's a huge victory for defense. It's a big difference. You get murder 1 reduced to murder 2. Big difference in relation sentence. How do defense lawyers defend murderers? Never ask. It's not your function. Your function is to give everybody an opportunity to have their matter assessed properly in a court of law. That is the defense counsel. Are your clients guilty? Most of them. I used to say, most of my clients are guilty and all of them are broke. That used to be, it's kind of tough on a young defense counsel. Get your money up front. Put that on the record. Criminal law. But yeah, thank you. You guys are great. I hope you stay in Canada, and I hope you have the kind of success that I anticipate that you're going to have. You're in the right age, the right time, the right circumstances. Go blow their doors off. Come on.
So before I invited Commissioner Kennedy to come, I knew by reputation about his fairness and capacity as a judge. And if I didn't believe that 100% before today, I think I believe it 110% now in terms of approaching, I guess in a broad sense, the ethical issues that he confronts as conflict of interest commissioner. And I think we heard the same thing yesterday from Conrad von Finkenstein, in a very practical way of ensuring that the public trust is respected. And I want to thank him for coming and sharing a very broad-based presentation beyond the actual specific functions of his office outlined in the legislation.
In other words, I kind of got carried away.
I don't think so. I think it was a benefit for all the whole class.